Kalpana. In this lecture, we are going to explore the nuances of Article 15 of the Indian Constitution, which is much debated and very important article when it comes to bridging the gap between haves and not haves. So that is equality and beyond, and we are going to explore what Article 15 is all about, a journey through landmark judgments which has shaped constitutional equality in India. Now, coming to the text of Article 15, which is provided under Indian Constitution, prohibition of discrimination on ground of religion, race, caste, sex, or place of birth. When Indian Constitution was commenced and drafted, we were fully knowing that these can be the grounds of discrimination where socially people are made felt demeaned because of their religion sometime, because of their race and caste, the most important, which had been a very humiliating and harassing aspect when it comes to discrimination being made on the basis of caste, and gender issues had also been the prominent, and place of birth also sometime. So that has been identified and recognized under Article 15 of Indian Constitution. So what does it say? Subclause 1 says the state shall not discriminate against any citizen on the ground only of religion, race, caste, sex, place of birth, or any of them. Subclause 2 says no citizen shall on ground only of religion, race, caste, sex, place of birth, or any of them be subject to any disability, liability, restriction, or condition with regard to access to the shops, public restaurants, hotels, places of public entertainment, or the use of wells, tanks, bathing ghats, roads, places of public resort maintained wholly or partly out of state funds or dedicated to the use of the general public. Nothing in this article shall prevent state from making any special provision for women and children. Subclause 3, which is a very important clause, which empowers central government and state government to make special laws or provision in order to empower two identified sections of society. First is women, which are the 50% of the world's population, which are vulnerable, and children. So, state is empowered by subclause 3 of Article 15 of the Indian Constitution to make a special law for em- empowerment of women and children. Nothing in this article, subclause 4, nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provision for advancement of any socially and educationally backward classes of citizens or for scheduled caste and the scheduled tribe. That is clause 4 of Article 15, which is enabling state governments and central government for making reservation in employment and providing the opportunity to backward classes, socially backward classes like scheduled caste, scheduled tribes, or any backward, educationally, socially backward people. That is also much debated. Now, coming to clause 5 of Article 15, nothing in this article or in subclause G of clause 1 of Article 19 shall prevent a state from making any special provision by law for the advancement of any socially, educationally backward classes of citizens or for scheduled castes, or for scheduled tribes, insofar as a special provision relate to their admission to educational institutions, including private institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in Clause 1 of Article 30. So it is empowering the government to make laws to provide reservation even in private institutions to socially and educationally backward classes of the society. Subclause 6 of Article 15 says nothing in this article or subclause G of clause 1 of Article 19 or clause 2 of Article 29 shall prevent the state from making any special provision for advancement of any economically weaker section of the citizens other than the classes mentioned in clause 4 and 5. Now, EWS in 2019 has been introduced by the government. People, even if they are born in Savarna or high caste, are economically downtrodden. So, in order to bring them and bridging that gap of social security, that a clause has been added recently. Any special provision for advancement of economically weaker section of citizen other than the classes mentioned in clause 4 and 5, insofar as a special provision relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in clause 1 of Article 30, which in case of reservation would be in addition to the existing reservations and subject to the maximum of 10% of the total seats in each category. So there is a cap of 10%. More than 10% seats cannot be allotted to EWS, economically weaker sections of the society. For the purpose of this article and Article 16, economically weaker section shall be such may be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. Recently, if a family is having less than 8 lakhs of income per annum, is considered as economically weaker EWS category. As of now, there might be changes further. Now coming to what you need to grasp as key concept about Article 15, formal versus substantive equality, equal treatment versus equal outcomes. Protective discrimination is allowed under Article 15. So positive discrimination for marginalized group who are disadvantaged and educationally, socially, economically are weak. Discrimination versus classification, understanding reasonable distinctions, as we have already discussed under Article 14, where there is a positive discrimination is allowed and reasonable classification, which is based on intelligible uh, differentia. So prohibition versus permission. Clause 1 and 2 prohibit. Clauses 3 to 6 permit. There are certain lot of landmark judgments because it is one of the most invoked article of Indian Constitution because it is in direct conflict of Article 14, which is talking about equality before law and equal protection of laws, whereas clause 3 to 6 of Article 15 are permitting and empowering central government and state government to make special laws to bridge the gap between marginalized sections of society and high class society, or you can say mainstream society. So a judicial journey through the most transformative cases that define constitutional equality in India. So the first case came the very next year, State of Madras versus Champakam Durai Rajan, 1951, communal reservation in medical colleges challenged under Article 15. And Supreme Court held reservation violates Article 15(1) as it discriminates solely on caste or religion. The impact is led to the first constitutional amendment, 1951, inserting Article 15, subclause 4 for socially, educationally backward classes of the society, which empowers the parliament and state government to make special laws to empower vulnerable sections and to empower the people who are marginalized sections of society. The first major case on reservation, this landmark judgment fundamentally reshaped India's approach to affirmative action. There is another case which came in 1963, M.R. Balaji versus State of Mysore. The issue was 68% reservation for backward classes in educational institution for challenge. The holding was excessive quota violates Article 15, subclause 4. Caste cannot be the sole criterion for backwardness. So, judicial innovation introduced the 50% ceiling rule, later affirmed the Indra Swane case, where reservation quota should not exceed beyond 50%. It cannot be 68%. Indra Swane versus Union of India, which came in 1992, that is also popularly known as the Mandal Commission case. Caste as marker, confirmed caste can indicate social and educational backwardness. 27% OBC quota upheld reservation but excluded creamy layer. That is a very, very important and historic judgment where OBC class was given 20% of reservation, whereas excluded creamy layer. What is creamy layer? People who are coming as caste OBC, but they are well off economically and well placed, so they are excluded from that 20% OBC quota. Article 15, subclause 4, reservations in education, not promotion. That is Article 16. That is also an outcome of Indra Swane versus Union of India. What is the discussion point in this case is the creamy layer concept justifiable? Should it apply to SC, ST also? That is a matter of discussion because once a SC becomes an IS officer or a doctor, should he or she avail the quota benefit? That is a point of discussion and debate. Now coming to another landmark judgment, DAV College versus State of Punjab. Key principle Article 15, subclause 1 prohibits both discrimination and reserved discrimination on listed grounds. Reinforcement special provision under Article 15, subclause 4 must be reasonable and proportionate. Significance is that establish limits on affirmative action to prevent overreach. There's one more case, Anuj Garg versus Hotel Association of India, which came in 2007. Challenge law prohibiting women from working in bars was challenged as discriminatory. That is very interesting. Before 2007, bars were not the working place for women. Blanket restriction based on gender stereotype violates Article 15. That was the ruling of the Supreme Court in Anuj Garg versus Hotel Association of India. Constitutional morality. State cannot justify protectionism if it reinforces patriarchal norms. That was the observation of Supreme Court in Anuj Garg case. So doctrine of constitutional morality, a landmark shift recognizing that protective laws can perpetuate discrimination when based on stereotype. So that is all about Article 15, which is very, very important when it comes to empowering certain sections of the society. And you should focus from clause 3 to 6 of Article 15, which in the first part of Article 15, it prohibits discrimination based on religion, caste, race, place of birth, and sex, but altogether it empowers central government and state government to bridge the gap between haves and have-nots, to provide reservation in educational institutions. So thank you so much. Happy learning.